Hi, Bill Henshaw here again, Constitutional Crisis Channel, and we have more malarkey. I mean, you can't believe how bad this is getting these days. But the good news is what the courts, quote unquote, are doing here. I mean, they're so afraid of the issues that I advocate and the issues that you can pick up and use yourself by getting my document packets. I'll talk more about that later. I mean, it's absolutely nuts. It's got to the point now, and I'm not authorized to. I can speak generically about the case, but I can't give you any information right now. But I have a case in Nevada, Las Vegas, and the person I'm working with there is still in jail. Luckily, she has an intermediary that I've been going back and forth with on email, so we're up to full speed. Got thrown in jail for 21 days, no bail. And I haven't seen the transcript yet, but what I heard from email was 21 days for daring to challenge the jurisdiction of the court. I've never heard of anything like that. I also know the Supreme Court and honorable courts say we can challenge jurisdiction at any time. And this girl had one of the best motions I've seen that I haven't done. It wasn't nearly up to my standards, but the guy that did this has been around some and has done some research too, and put this motion in unopposed, and she gets thrown in jail 21 days. And the charge, by the way, is dancing on the street without a license. This is Las Vegas for you. Probably something for which you can't get thrown in jail, although they seem to think it's criminal. But I went through the whole Las Vegas municipal code from which this charge was taken, and I searched it carefully. I could not find the word jail, crime, misdemeanor. So how this can be a criminal case, I don't know for openers. How someone can get thrown in jail for 3 weeks for a case that's not criminal, for contempt of court, I don't know. How the court, quote unquote, has contempt powers, I don't know. Oh, the judges are going to love to hear this one by the time I get a hold of this black robe bastard. But they don't. I mean, I can prove that this is a federal territorial legislative tribunal. How they can possibly have judicial contempt powers, that's a real good question. And this guy had better be a first cousin of Harry Houdini, and even that might not help. I mean, it's just not there. They don't get it. But that's what we want to teach them and say, not so fast, as Lee Corso would say in college football during Saturdays coming up here. You know, you don't have any of this, and we have proof, and your prosecutor isn't opposing us. So you should take great care here, remembering that you have an oath of office to preserve, protect, and defend this Constitution. You're bound by Article 6, Section 2, in case you forgot, you judges out there. That's what you're sitting there and supposedly doing. It's just the opposite of what you're really doing, and I hope most of you are not doing it knowingly. But be aware that it doesn't matter one way or the other, because you got 3 strikes and you're out. There's 3 strikes. You're claiming on a voter registration form that you owe your citizenship to the 14th War Amendment. You've accepted a position in government that requires you to be appointed by the president or a territorial governor, which has not happened. And you have the oath of office, to which I've just mentioned, and you're not going to obey any of them. And anytime we get you in front of an inflamed common law jury, I'm going to eat you alive. I mean, you can't be doing this. You've got to understand what the real situation is out there. And we put all these papers in. I don't know if it even gets to the judges to read and understand, or whether if they read them, do they understand them? I mean, law school is so poor these days, you wonder what the hell they're teaching in there for 4 years. I mean, my goodness. So that said, I'm trying to keep it as friendly as I can here. Because we all should be on the same side here, especially those of you that belong in official positions in local government. That's the government that has most of the power here, like we're supposed to have. Not like it's all been delivered to Washington, D.C. these days in the de facto national government. None of the framers would have any comprehension of how that could have happened. I mean, you read and study the debates of the Constitution and early decisions and early debates in Congress. And some of these debates, by the way, my gosh, you could almost break into tears reading this stuff, how good they were and how true they were to the original intent of the framers, especially in the admission of Maine and Missouri in 1820. And if you can Google that these days, thank goodness, you can Google it. It's called, I can't think right now, but I'll get it for you. But it's the Congressional Record, but it wasn't called that then. So it's called Annals of Congress is what it's called. and I think it's 12 annals of Congress. It has debates on the admission of Maine and Missouri, the biggest issue I think that's ever been before Congress. That's how important it was, because, just a brief summary, what happened was at the time, we had a balance between North and South. So we had equal states and equal representation in Congress. And what that meant was the South was agrarian at the time. They relied on raw goods, cotton, tobacco, what have you. The North wasn't all that much industrialized at that point, but much more so than we were in the South. And if they had the power to control both houses of Congress, they could have tried to pass laws that would in effect put the Southerners out of business, which is exactly what happened in 1830 with the nullification crisis, a story for another day. But that said, Maine and Missouri, the deal was that the Northerners wanted to admit Maine as a free state, no problem. But they said to Missouri, you can't come in as a slave state. You can only come in here under such terms and conditions as Congress will permit. That's not how it was designed to work. Congress does not create states. They have no authority to tell them on what terms and conditions they're going to come in to this union. That is so important, and you read the speeches there, especially of John Holmes, who was a Federalist from Massachusetts, for crying out loud, in the House of Representatives, who made a speech on this, and the senator from Maryland, whose name I'll think of in a minute, that made a speech. That was a border state at the time. But you read speeches of this level of comprehension, understanding, intelligence, and integrity, and the first thing you say is, where the hell are these people today? We haven't got anything remotely resembling this. By the way, it was Senator Pinckney of Maryland, Pinkney. In fact, if you want to send me emails, I think I have those in digital form I can send you. So please do. That's ccaspari@libe.com. And I'll send you some of the debates from the admission of Maine and Missouri. You'll see how important that was and is. And you'll get the idea for when I say that there are no states in this union. There aren't any, because this union, as such, has been in a state of abeyance for 150 years. So any state that was admitted after Minnesota on February 14th, 1859, was not admitted into this union. And the states that were summarily escorted out of this union and apparently relegated to federal insular territorial possessions in apparent pursuance of the non-existent 14th War Amendment. This is how serious this business is. And yeah, on the surface, it was certainly going to appear to be a white supremacist argument, and much of what I argue is. But when you understand the meaning of it, that's when it hits home. You're saying, wait a minute, you people of color, you got nothing from these war amendments, except the continuation of your being slaves, even though you're maybe not openly slaves. But anytime the government can tax you, and the Supreme Court has said that the IRS can tax you out of existence without any apparent need for an administrative hearing, because in effect you have no right to your property in the form of your time and labor. If that's the system you're in, I find I'm hard-pressed to see what the difference is from the slaves 150 years ago to what it is now. By the way, you can look the case up. I don't make this stuff up. Case is called Enochs, Enochs v. Williams, 370 U.S. 1. So that said, we'll follow up more on this next time. I'll give you more details about it. Thank you.